Today I'm gonna cover this article which is in the Hindu newspaper Delhi edition. So which is based on the numerous referential questions asked by President of India to the Supreme Court with respect to the landmark judgment that came in April 8 regarding Tamil Nadu Legislative Assembly bill. So it was placed by the president during the tenure of I think the 51st CJI, which is Sanjeev Khanna. But now the 52nd CJI, which is Gawai, is gonna give the advisory jurisdiction to seeking by the president with respect to the Constitution Article 143, subclause 1. So she has placed nearly 14 questions to the Supreme Court. So, okay, what is the context on this? It is Tamil Nadu state legislative has passed numerous bills. Nearly 10 bills has been passed by the legislative assembly to the governor's table, but the governor has not signed because see, I'll tell you one more thing that the regarding veto powers, governor doesn't have the pocket veto power. He has only absolute veto and suspensive veto. Okay, governor has only absolute and suspensive veto, but only the president can have the pocket veto power. Okay, so this is one perspective. So the bill submitted by these legislature was meant to be reconsidered by the governor, which is the suspensive veto. Suspensive veto in the sense reconsidering the bill. Okay, so even after reconsideration, if the legislature is passing the same bill with or without the recommendations made by the governor has to sign. He has to give assent to the bill. But what he had did is, after reconsidering, even though that bill has been reserved for the president's table, so reserving the uh, first I'll tell you the assent to the bill. So article 200 is the giving assent to the bill by the governor passed by the legislature, state legislature. Okay, giving assent. Article 201 is reserving it for the president's table. So in that means we can see this article. So first, on what perspectives the governor can give an assent to the bill. Okay, so article 201 is reserving the table, reserving the bill to the president's table. So the president has submitted numerous questions regarding the judicial power. Can the judiciary be implementing the task to the executive and also set timelines and frames for performing the task by the executive? Can it be a judicial overreach? Like it seems to be like a judicial overreach, right? And also she has asked about the powers of the governor and so the thing is, can it decline a reference? Can judiciary decline the questions referred by the president? Yes, it has the provision to decline a question which is meant to be not a public importance by the Supreme Court, or if it involves, it can be a political thing. So, on those perspectives, it can actually refuse the question submitted by the executive or a state. But this particular question has been taken into account by the Supreme Court that we will give advice, we will be replying to it. So but it also has the provision to decline. Okay, it is based on the constitution, because in constitution under article 143 it is given it may or may not, the word may is presented. Okay, which means it may or may not. But if the president is asking a question regarding the pre-constitutional laws, which is the IPC sections, or any like before constitution there was a law made by the British government, right, which still is in the Indian lawmaking process. So if the president is asking certain questions on that basis, which is pre-constitutional law, then the judiciary has to give, it is obligation of the judiciary to give advice to the president. Okay, so this is one perspective you have to know about this. And or advisory opinions binding to the executive or the state or by the president. is the advisory given by the jurisdiction is binding to the president of India or not. It is not actually, in the sense like the advisory given by the Supreme Court can be taken or with advice like it is up to the discretionary of the president. She can hear it or not. Okay, so it is also there is a two cases given here in St Xavier College versus State of Gujarat. The court clarified that advisory opinions do not amount to binding. So in this case, that is St Xavier College versus State of Gujarat, it has said that the binding, I mean the president is not binding to the advisory jurisdiction. Okay, and in the second case in 1981, Justice P.N. Bahawati, the uh, justice who has seen this case, which is R.K. Garg versus Union of India. So in this case, they are mentioned that it is binding to the President of India. But according to the Constitution, it is actually not. It is up to the discretion power of the executive or the state. So based on this context, there was numerous questions can be asked in the prelims point of view. And see, I have to tell you this assent to the bill by the governor, right? So giving assent to the bill. So the one first thing is that he can actually accept the bill. He can actually withhold in the sense it is like reject kind of thing, and he can give it for a reconsider, or he can give it reserve it for the president's table. Only these four can be performed by the governor. So this is what the power of governor with respect to the state's bill. So this is what the overview of this article. So let's see what it is, a landmark judgment. Okay, so there can be mains question also on this perspective. So note down what are the 10 bills submitted by the legislature on that topic also, because there is a provision in which what kind of bill has to be reserved for the president's table. That is also in the constitution, only that it mentions only if it affects the apex of the high court. If any of the bills submitted by the legislature is affecting the power or judiciary of the high court in the sense, then only that particular bill can be submitted by the governor to the president's table. Other than that, he cannot do it. So what he has done, the 10 bills which is passed by the legislature, it is none of the bill is affecting the power of the high court, but he has reserved it for the president's table, in which Supreme Court has declared that the governor's mannerism was illegal. So this is what the judgment based. I hope you had a clearance from this article. If you have any doubts, you can ask me in the comment section. And I hope you like this video. If you feel it is useful, you can like and you can subscribe, and you can get updates from this channel. So thank you. Thanks for watching.